Well, hello and welcome to another episode of the Legal Gym Podcast. Thank you so much for joining me today. Today, we're going to be talking about how to properly and legally name your business the right way. Was that a little redundant? That might have been a little bit redundant. I apologize for that. But for the show notes for today's episode, which will include all of the links and resources for everything that I'm going to be discussing today, make sure you head on over to hawthornelaw.net/17. Good. All right, let's dive in. But before we get into the amazing content for today's episode, I want to let you know about a new training that I am working on. I'll be teaching my 4R framework to get your trademarks registered quickly and easily. In addition, I'm going to be sharing the top 3 mistakes that I see online entrepreneurs make that can sabotage their brand and even force them into bankruptcy. So if you want to sleep better at night knowing that your brand is protected, you don't want to miss this training. Just head on over to hawthornelaw.net/trademark to get notified when the training is live. That's hawthornelaw.net/trademark, and everyone who attends this training is going to get a free gift from moi. If you are an entrepreneur who is building a brand online, this is one training that you definitely do not want to miss. One more time, head on over to hawthornelaw.net/trademark to get signed up for the notification list today. All right, so if you are a brand new entrepreneur, or maybe you've been in business for a while and you've got a brand name that you're either thinking about using or maybe that you're already using, and you want to make sure that that brand name, number one, is memorable, number two, is amazing, because you want people to hear your brand name and think your product, think your service, and get so jazzed about what you're doing. And a name can do that. A name can really create a lot of emotion in your clients and customers, and it can force them to want to purchase from you. So you want to make sure you get the name correct. But where I see most entrepreneurs run into problems is, number one, they aren't sure what to name their brand. They don't quite know how to go about this process of coming up with a name for their brand. They want to make sure they're not infringing on anybody else, because that's a concern. Some people think about this, some people don't think about this a whole lot, to their detriment. But most people want their name to allow others to understand what it is that they do and what it is that they sell. And lastly, they want to make sure that you own the rights to your name. You want to go out there and be able to do a webinar or do a big promotion on Facebook and not be concerned that somebody's going to come down the road and steal your name. So there are a lot of things at stake to getting this wrong. And I hate to be the bearer of bad news. I'm not trying to do it that way. But some of the things that could happen is and probably this is the biggest thing, you could be what's called an accidental infringer. And an accidental infringer is somebody who comes up with a great name for their business, and they start operating under that name. And then one day, when their business gets big enough and they get onto the radar of some other competitors in their field, they receive what's called a cease and desist letter, which is a letter from a law firm, typically from a lawyer, that basically tells you all the horrible things that can happen if you don't immediately stop selling under that brand name. And the reason for that is because the client of said law firm typically owns the trademark rights to that name. And so by owning the trademark rights, they have exclusive rights to use that name in the United States. And they also have exclusive rights to use that name with regard to the products or services that they sell. And so if you sell products or services that are similar to that, and your name is too similar to the name that they've registered, then they're going to send you a cease and desist letter. And what all this means is you could be forced to either A, rebrand your business, which is not great. It can cost a lot of money. It can cost you a lot of money in inventory if you're a physical products business. B, it could cause you to actually go out of business. I've seen other entrepreneurs that, because they received a cease and desist letter, they could no longer operate their brand the way they wanted to. They lost their name recognition. They didn't have necessarily as loyal a customer base as they would have liked, and they went out of business. It could even force you into bankruptcy, and this is especially true if you're in a physical products business where you've got a lot of inventory tied up with loans to either the bank or to the vendor that you're purchasing the inventory from. It's all been branded the way you want it to be branded, and the cost to rebrand all that inventory, not to mention the cost because you're no longer allowed to sell under that name, you basically have a bunch of inventory that you can't use anymore. And if you can't sell that inventory, then you can't pay back the loans that were necessary to purchase that inventory in the first place. So that can be a problem. It can actually lead you into bankruptcy. So you don't want that to happen. So this is where trademark lawyers can help. And yes, I am a trademark lawyer, but I'm going to give you the information you need today to make the right decision. If you need more help or guidance, obviously we're here to help you. But I really want you to have this information so that you know and don't make the mistakes that I see so many entrepreneurs make when they get on the phone with me. So the first thing you need to know is that not all names are created the same. What do I mean by that? I mean that you need to pick a name that's not overly descriptive, that's not overly generic, but is capable of being trademarked. And so there is a continuum with the U.S. Patent and Trademark Office between different types of names. And descriptive names and generic names, these names are not capable of being protected. So generic names would be like milk. If you're selling milk and you want to call it milk, well, you can do that. Nobody can register the name milk as their trademark. Then you've got these descriptive names, and this is where you have a name like the dog food store or the milk store or the coffee store or the scuba diving store or the computer store, whatever you want to call it. Anything like that. That's very descriptive of what you're selling, assuming that what you're selling in the store is actually computers or milk or dog food or scuba diving equipment or whatever. So if you're naming it something like that, that's a descriptive name, and that's not capable of trademark protection either, because anyone should be able to name a store and describe what it is they're selling in the store. There's nothing unique about that. And to protect the marketplace, the U.S. Patent and Trademark Office has said that you cannot name something that's overly descriptive and you can't claim the rights to that name. Then where do you go from there? Well, you need to pick a suggestive name, an arbitrary name, or a fanciful name. And the differences between these names are basically, the fanciful names are basically made up words. They are names that you've come up with on your own. You've made up a name. It's a new name. You are going to have to spend a lot of time and money educating the public, educating your customers about what it is that you do, because the name is made up and somebody might not necessarily understand what it is you do. So I think a good example of this, I think this is a made up name. I could be wrong, but Uber. Uber I am intimately familiar with right now because we use it all the time here in Portugal. And I don't know if Uber is a made-up name or not. It sounds to me like it would have been a made-up name, but the company that started Uber certainly would have had to do a lot of work educating the public about what Uber meant before they started selling the brand, or even while they were selling the app to the public. It was a completely new, unique, different service. So aside from fanciful names, you've also got arbitrary names. A great example of that is Apple Computer. You've got a name, Apple, that is the name for a business that sells something completely unrelated to Apple. So if you had the Apple store and all you sold was apples, not capable of trademark protection. But obviously Apple, as it applies to computers, is capable of trademark protection. So again, arbitrary names like that, it requires a lot of time and money to educate the public about what you're doing, but they're very good names for trademarks. Then you have the more suggestive names. So suggestive names are kind of like when I named my business Hawthorne Law. Hawthorne trees, for those that you don't know, were used, or actually hawthorne bushes or vines were used hundreds of years ago to protect property because they have very big thorns on them. And so they were put around property to keep people out of people's property, kind of like big fences with, barbed wire in today's day. But that's what people did to protect their property. So I picked Hawthorne Law because I thought, well, that is a great analogy for helping people to protect their intellectual property. And so that's why we picked Hawthorne Law. Now, again, that is a suggestive name to what we're doing, and that is capable of protection. So we registered the trademark to that. If you are trying to come up with a name and you're brand new or you've been in business for a while, think about whether your name is descriptive of what you sell, if it's suggestive of what you sell, or if it's something completely different, because all of that is going to have bearing on whether or not you're able to actually register the trademark for your brand. because overly descriptive names, generic names, are not capable of federal protection. So that's the first thing you need to know. You need to pick the right kind of name, not too descriptive, not too fanciful. You want to get something right in the middle, just like Goldilocks and the Three Bears. Not too hot, not too cold, just right. That's where you want to be with your trademark. Once you have come up with a name, or evaluated the name that you're already selling under, you want to make sure you do a comprehensive search to make sure your name is not taken by another business. And this is super important. And the way you do this is you need to review the U.S. Patent and Trademark Office database. You need to look for exact match names. You need to look for near match names. You need to look for phonetic equivalents. You need to look for all sorts of different variations of your name to see if anybody else is selling something very similar to what you're selling and using a name that's very similar to what your name is. Because what the Trademark Office is going to look at, they're going to look at whether or not there is a likelihood of confusion, meaning is the public going to be confused if they see your mark compared to somebody else's mark. And a great example of this that I heard from another lawyer on a podcast a while back was Blue Apron, which is a grocery service in the United States. They were selling, and another company came in and they wanted to register, let's just say, Green Apron. I'm not sure what it was. And the Trademark Office actually rejected that application because Green Apron was too similar to Blue Apron. And if the public saw a sign or a service selling Green Apron services, they might think that they were actually buying Blue Apron and it was some sort of special where they changed the name to Green Apron for a day or for a week or something like that. So the U.S. Patent and Trademark Office, the USPTO, rejected that name. So that's what I'm talking about. It does not have to be an exact match name. It just has to be a name that is likely to cause confusion in the marketplace. And if that's a much different standard. That's a much lower standard. And if your name is too similar to another name, it will get rejected. So you need to make sure you do a comprehensive search ahead of time. You want to look, and I will also mention, other than just looking at the USPTO database, you want to be looking in the search engines. You want to look in Google. You want to go to Amazon. You want to go to Facebook. You want to look in the podcast directory on Apple. You want to look all over the place to see if somebody else is using the name that you want to use. Or something similar to what you want to use, because that's going to give you a good indication if there's other people already selling your name. Another example I talk about with people before is in the coaching space. A lot of people use the name Accelerator in their coaching programs. And it's funny because there's so many coaches out there that are using the name Accelerator in their coaching name that it's lost any type of uniqueness in the market. And everybody has an accelerator program. So that's not something, if you want to name your coaching program the Accelerator program, you're not going to be able to register it because there's too many other people in the marketplace that are using that name. And it's just, there's no real tangible benefit to having that name because it's not unique and it's not something that you can sell. It's not something you can license. And so you just need to be aware of things like that. You don't want to name your name. I did it again. You don't want to name your business something that a lot of other people are already using as their business name. All right. So once you have done your comprehensive search and you feel pretty confident in your name and you know that your name is not too descriptive, then you want to go ahead and file that trademark application as soon as possible. And the reason for this is your search is kind of like a snapshot in time. If you were to go back to the same location, if you took a picture of a place and then you went back to that same location a month later or 3 months later or a year later, it isn't going to look exactly the same as it did when you originally took that picture. And the reason for this is that the trademark landscape is constantly changing. There are thousands and thousands of applications that are getting filed each and every day. And chances are that if you did a search and then you did not take the steps necessary to register that name through a trademark application, somebody else could have come in and actually filed an application for that same name. And I've told this story before. I'll tell it again. I was working with a client about a month ago, and we were doing a search. We'd come up with a great name for her, and she was all ready to move forward on filing the trademark application for that name. We did a search, and lo and behold, we found somebody who had filed an application for almost the exact same name, selling the exact same services a week prior to when we were doing the search. 1 week. So if she had done the search 2 weeks earlier and filed that application right away, no problem. But because luck of the draw, we just were looking at the wrong time, and, put it off a little bit too long, the name was taken by another company that had filed to register that name. So that requires a rebrand. That requires coming up with a new name and doing more brainstorming and all those things. Even when you think you have the perfect name, until you're doing that search, you're not sure. And then even once you do that search, you got to get that application filed as quickly as possible. So if she had done the search, let's say she'd done the search 2 weeks prior to that and then sat on that search and not done anything, then if she had filed her application 2 or 3 weeks later after the other company had already gone in and filed their application, then her application would be lower down the totem pole in priority than the other person that was trying to register that name. Now, I will tell you, just because somebody registers or files a trademark application does not mean it's going to go through. There's lots of reasons why trademark applications do not go through, and there's lots of people that file them without the help of a lawyer, and then at some point things get tricky. The attorney that's examining the file asks for something and they don't know how to respond, and so they end up abandoning their application. Or maybe they just filed thinking they were going to be going into business, and then they decided not to go into business, and so they just let the application lapse. So just because there's a trademark that has been filed ahead of you that hasn't registered yet does not necessarily mean it's going to register. But at the same time, you don't want to play that game of waiting around for a year or so to see if this name registers and using your name all the while. You should just come up with a new name at that point. Registering your trademark, in terms of legally protecting your business, you need to pick the right kind of name, you need to do a search, and you need to go ahead and register that trademark. It's going to make you sleep better at night. It's going to give you more confidence to know that you can go out there and sell your products, sell your services without fear that somebody's going to be stealing your name. And it's going to add value to your business. You can license your trademarks. You can, if you ever decide to sell your business or your brand, it's going to increase the value of your business. I'll tell you another story. I know an entrepreneur a while back that wanted to sell their brand, but they had not registered the trademark for their brand, and it actually threw a wrench into a potential sale, potentially cost this person hundreds of thousands of dollars, when the company that wanted to buy would not close on the sale until they had done a trademark search and they had at least filed the rights to their trademark application. Now, they may have actually been asked to register the trademark before the sale could go through. And if that was the case, we're talking another year and a half, 2 years before that sale could have gone through. So you want to make sure you get your trademarks registered. It's just going to save you a whole bunch of headaches down the road. Not to mention, it's going to just increase the value of your business and give you a lot more confidence when you're running your business. All right, all you Legal Gym listeners, now that you know more about how to legally protect your online business and pick the right name for your business, you are ready to implement. Because there's one thing we love to do here at the Legal Gym, it is to take massive action. So if you haven't already, make sure you check out the show notes for today's episode. You can get a rundown of all the links and resources we talked about here today by visiting hawthornelaw.net/17. That's hawthornelaw.net and then /17. In addition, if you're interested in learning more about how to legally claim the rights to your brand name, then you will want to schedule a free branding strategy call with me. That's right, for a limited time, I'm offering a free strategy call to talk with me about the branding for your online business and how to make sure it is legally protected. If you'd like to learn more, head on over to hawthornelaw.net/TM-video. Once again, that's hawthornelaw.net/TM-video. On that page, we have lots of great information about the process of protecting your brand so that you don't have to worry about getting a cease and desist letter or being forced to rebrand or even potentially bankrupt your business. Once again, that website is hawthornelaw.net/TM-video. Thank you so much for listening. I look forward to seeing you I'm not going to see you, but I look forward to talking with you in the next episode. Take care, folks, and we'll see you next week.